but they can't contract away their accountability. I dare say that if such an airplane comes back and maintenance is improperly performed, as you know, it renders the aircraft unairworthy. If the carrier then conducts revenue flights using that aircraft, each flight would be a flight in which an unairworthy aircraft was used, for which they would be accountable. So there would be a sanction apportioned both for the improper performance of maintenance and for each unairworthy flight. So let's take that concept and apply it to operational control in the context that we're dealing with it today. Now, the FAA will not permit an air carrier to transfer away its duty to provide air transportation with the highest degree of safety in the public interest. So, we're not going to let a carrier transfer away, unlike maintenance, which you can contract out that function. With respect to operational control, you cannot contract it away to an uncertificated entity to conduct operations as if they had a certificate using the color or cover of your air carrier certificate. It just cannot happen. And if any of us have let that happen in the past, we have to make sure that we will never let it happen again. Now, my lesson learned: an air carrier cannot be driven by its business practices or business models to create an environment in which uncertificated entities operate flights for compensation or hire under the apparent authority of the air carrier certificate. Remember before I said you don't get something for nothing. Now, this half of Darby's operation, the half in which was using leased aircraft, well, it wasn't using anything. It did not exercise operational control. The uncertificated entities did. All Darby did was collect several $1,000s per month for each aircraft on its op spec. That's getting something for nothing. That's a red flag. They, in essence, were being driven by a business model that was making them money. So be aware of that. There was something else. Oh yes, platinum. We didn't let platinum go untouched either, by the way. Shortly after issuing our emergency order of suspension, we issued an emergency cease and desist order against platinum, and ordering them immediately to cease and desist from conducting operations for compensation or hire when they did not hold an air carrier certificate. In addition to that, we issued a civil penalty letter against Platinum, its principals, Brasington, and a couple of others, and an in rem action against the aircraft that were leased to Darby. I think the total was about $1.8 million. While Platinum has complied with the cease and desist order, we have not settled the civil penalty action, and it's been referred to the appropriate U.S. Attorney's Office, and the results will be somewhat down the road. I must add that when I did, actually, to me it was a lot of fun. You have to have fun because you do enough of these, you need different things to keep you alive and awake. But at Fort Lauderdale, Brasington, the CEO of Platinum, asked some questions, and I had a hell of a good time responding to him and letting him walk away with his shoulders slumped down. He was confused. He told me that, you know, hey, the FSDO said it was fine, this, that, and the other, and I just reiterated what I said to you all. But the more interesting one was Atlanta, where the, oh, I'm sorry, this was Fort Lauderdale too. Platinum's attorney also asked me some questions, Mike Melise, and he said, and this was in public, he said, Alan, I'm so confused. What can I tell my clients? This operational control thing is just so confusing. And I said, Mike, you remember the list of factors I rattled off at the beginning of my presentation? I said, if you ask questions similar to that, you'll be able to give the appropriate guidance to whoever wants to be your client. Because all you have to do is fold that paper down and put a little check mark on each side and you'll figure it out. Then when we were in Atlanta, Mr. Morrison, the chief pilot for Darby, he also tried to ask some questions, and I responded to him in the first half of my presentation, and at the break I was told by everyone, oh, you better look out, he's going to really get you with all these questions. So he was in the first row, and I basically was looking him in the eye, and I used the words Darby and Platinum, and held them out as examples of what not to do in the future. And believe it or not, there were no questions at the end of that. He was silent. He didn't even have a sidebar question, because I think they get it now. You know, the bottom line on Platinum and Darby, neither of those entities wanted the accountability for that which they did. And, you know, that's just intolerable. And I'm not a hardhead. I'm just a realist. I hold myself accountable for when I screw up, and I'll admit my mistakes. And if I screw up in a legal sense, there can be disbarment actions taken against me. Air carriers similarly have a high level of public trust by holding that certificate, and action can be taken against their certificate when they do something that jeopardizes the public interest, like relinquishing operational control. American Air Network, that was a case that was tried by our Southwest region. After 2 days of hearing, American Air Network chose to settle the case by accepting the revocation. In that case, American Air Network illegally rented out use of its air carrier certificate. They lacked the necessary systems and information to make responsible operational control decisions regarding flights and air transportation that ostensibly were conducted under their certificate. And they didn't have any adequate systems to track flights, pilot records, aircraft maintenance. They really said, we're making sure that everything's done correctly. Now, I'll go on to say that American Air Network wasn't trying to deceive FAA. They couldn't have been more out front. We just didn't see all these obvious signals. As a matter of fact, a year or so before this case, the Western Pacific region took an action against American Air Network for a civil penalty action. This was before we really knew the depth and scope of the operational control problems and issues. And I just want to read you some testimony from Mr. Gilliland, the head of American Air Networks. And it'll show you, he's up front, and it'll also show you how clearly he had no problem thinking it was okay to rent out or franchise out his certificate. Here's what he said. He was asked, what's a DBA? He says, doing business as. It's doing business as. It's doing business as the other names listed on my A001. Question. Okay, you're doing business as? That's an FAA DBA, not a state or local licensed business. That gives them, the DBA, the authority to hold themselves out as an aircraft charter, answer their phones and invoices and such. And that gives them the opportunity to hold themselves out as an air carrier because their name is on our op specs. Well, this confused the ALJ just a little bit. So here's the judge. If N600XJ were dispatched today, you could fly it under Jet Management, Inc., just throwing out an air carrier name, and you may send it out tomorrow as Airlift Transport. Mr. Gilliland, no. it would be the owner or lessor of the aircraft. They operate the aircraft under that specific DBA. We have a DBA associated with each aircraft. You have a DBA to operate a corporation. Would that be a fair statement, Attorney to Gilliland? As is my understanding, it allows them to answer their phones, invoice customers directly without American Air Network's name, and hold themselves out as a charter company strictly because their name, that name, is mentioned on the A001. But you're not involved in the management of the company? That's correct. Okay, and here's the coup de grace. These other entities haven't gone through the official FAA process to get a 135 certificate. Is that correct? Answer, the companies have not. That's correct. Question, they don't have a Part 135 certificate of their own. Is that right? That is correct, or they wouldn't need me. That is a gem. But he wasn't trying to hide anything. He was blatantly renting the certificate out. Some people do it blatantly, some are a little more subtle, but neither is permissible. So, what are some of the factors regarding the illegal renting out or franchising out an American Air Network? Well, they listed the names of the owners or lessees or lessors of each aircraft on their ops specs as DBAs. Now, at the time of this hearing, there were 19 DBAs. A year or two before that, I believe there were 69 DBAs on American Air Network's ops specs. Do the math. Even at 19, and depending on the type of aircraft, they got between $2,000 to $5,000 per month per aircraft. Now, even at 2,000, it's $38,000 a month for doing nothing. And at 5,000, you're reaping millions of dollars. And if there were 69 aircraft at one time, look at all the money they made for doing nothing. People, that's a red flag plus. Okay, the lessor was responsible for the entire risk of loss, damage, or destruction of the aircraft, and was required to indemnify and hold American Air Network harmless from and against all claims in contract, tort, or otherwise arising from the use of the aircraft. And they got the flat monthly fee. They didn't have an exclusive use aircraft. Each of the aircraft on their op spec was leased. They didn't employ the pilots directly or as agents, and they didn't exercise operational control on any of the flights. Now, I'll leave it up to you. I have one more case in policy. We could either break for lunch and I could pick up then, or if you want to go with the flow, I generally work till 2 before I break at lunch, but I don't ever want anyone to do what I do. If everyone wants lunch, show of hands, lunch or not? Gee, I would have thought more of you wanted lunch. But we'll bow to those who want it, and we'll pick up in an hour. It's about 5 after 12. Why don't we come back about 5 after 1? If everyone's ready, I think we left off discussing American Air Network. And one of the things that Flight Standards has been doing with respect to American Air Network, they have been tracking American Air Network's aircraft to see if they're attempting to get on anyone else's certificate. And I think Kent would have more background on that, but that's the extent of my knowledge on it. The next is another Eastern Region case, American Flight Group. And American Flight Group held an air carrier certificate for 23 years. I'm assuming that when they initially obtained their certificate, they were a legitimate operator. But by the time we discovered what they were doing, in essence, they were nothing more than a kitchen operation. And by that I mean when our investigative team went out to their principal base, the principal base was the owner's, the kitchen in the owner's house. They weren't at the airport, they were in his kitchen in Annapolis. And they didn't have exclusive use of any aircraft, they didn't own any aircraft, everything was leased. And everything you see here with respect to American Air Network is pretty much present with American Flight Group. They too lacked necessary systems and information to make responsible operational control decisions for flights for comp or hire, conducted ostensibly under their own certificate. And they didn't have adequate systems to track flights, pilot records, qualifications, training, medical. Couldn't track aircraft maintenance. They were merely a shell, a subterfuge. It was a nice business model. They got several $1,000s a month from for each of the 8 aircraft that were placed on their op specs. It's not a cold, it's allergies. Maybe it's just talking too much. As I said, they leased 8 aircraft. 4 were leased from an outfit called Medway Air Ambulance. Now, Medway did not hold an air carrier certificate. 1 was leased from Alton Corporation, who also didn't hold an air carrier certificate. But it gets a little more convoluted now. 1 was leased from Trans-Caribbean Airways, whose air carrier certificate was under an emergency order of suspension because that company plus 6 others last summer, their certificates were suspended because their principal base of operations was somewhere in the Caribbean and not Puerto Rico or U.S. Virgin Islands, and they didn't have a principal base of operations in the United States. In addition, the last 2 were leased from certificated air carriers, one called Aeronational and the other M&N Aviation. Those air carriers, however, were not authorized to operate the type of aircraft that they leased to AFG, and they weren't on the carrier's op specs. Now, if I referred to these lessors as lessors or clients, and you looked at the op specs for AFG, these lessor clients were not listed as persons who were authorized to exercise operational control on behalf of AFG. Under these agreements and the manner in which they were implemented, it's pretty clear that AFG surrendered operational control of their flight operations to the lessor clients. For example, the lessor clients provided the aircraft, maintained and paid for the maintenance of the aircraft, provided and paid for their own maintenance personnel, prepared and kept permanent maintenance records, employed and dispatched the flight crews, provided, scheduled, and paid for pilot training, provided flight and other crew scheduling, prepared trip itineraries or flight manifests, scheduled and released the crews for the flights, solicited customers and provided charter quotes, invoiced the customers and collected the revenues, paid for the aircraft fuel, provided aircraft insurance, and merely paid a flat monthly fee of several $1,000s a month to AFG for the privilege of placing the aircraft on AFG's op specs. Now, we looked at about a 5-week period during the course of the investigation, and we found that these lessor clients operated in excess of 125 flights for compensation or higher in that 5-week period. 85 of those flights were operated by Medway. Now, in some of our presentations, we were told we didn't put enough emphasis on the maintenance piece, and all we do was talk about the ops piece. But I think AFG is a pretty good example of how they demonstrated that they lacked operational control with regard to the maintenance aspects of their purported operations. When you looked at their maintenance record system, you could not determine the current airworthiness status of the aircraft that supposedly were operated under the authority of their certificate. And their maintenance record system did not accurately notify flight crews of the current maintenance status of the aircraft. And because of those failures, maintenance either was not performed or was improperly performed. In other words, the aircraft were therefore operated when they weren't in an airworthy condition. In addition, one other kind of interesting aspect to this was that their chief pilot never was in the boss's kitchen. Quite frankly, he was located in Lawrence, Georgia, and was employed as a pilot by Medway. So they also didn't have sufficient qualified management personnel. He didn't immerse himself in the day-to-day decision-making functions that a chief pilot ordinarily would do. So AFG, in essence, had no involvement in the initiation, conduct, or termination of any of these flights that were conducted under the apparent authority of its operating certificate. Now, people have asked, so what's the safety link here? Again, I started out this way. What is the big deal? Well, if AFG didn't have a system in place with regard to pilot qualifications, such as training certificates they held, medical certificate status, whether or not they had received the appropriate training, whether they exceeded flight, duty, or rest requirements. Before these guys took off, how could they make a decision that they were ready to go without violating the regulations? If they're too tired, if they're not qualified, if they're improperly trained, that has an immediate and a direct adverse impact on the safe operations of flight and air transportation. Similarly, with respect to airworthiness issues, if in fact they did not know the current airworthiness status of an aircraft before it was released on a flight or series of flights in air transportation, and if they were unable to inform the flight crews of the airworthiness status of the aircraft, that too has an immediate adverse impact on the safety of the operation, because you can be, and undoubtedly they did, operate those flights for compensation or hire when the aircraft was not airworthy. Fortunately, it was still flyable, but not airworthy, and which could have led to, resulted in a greater potential for a catastrophic event to happen. So, when I look at the AFGs of the world, and I look at the American Air Networks, you reach the conclusion again, while it might be a profitable business venture, an air carrier cannot rent or franchise out use of its air carrier certificate to uncertificated entities or certificated entities that are not authorized to conduct operations or that type of operation, because safety is compromised when the certificated air carrier is either unwilling or unable to maintain operational control over commercial operations. before I go on, we did take action against Medway. What we've learned in these exercises is that when an air carrier rents out or franchises out its certificate, the investigative process is very complicated, and it results in a number of different enforcement actions that are in different forums. With respect to AFG, they didn't challenge the emergency nature of our action. They had 48 hours to petition the NTSB regarding the emergency nature. In other words, whether to treat it as an immediately effective order. They failed to challenge that. They did, however, file a notice of appeal with the NTSB. And the case was scheduled for hearing, I think on June 12th. Several days before the date of the hearing, after their attorney had the opportunity to at least initially examine the 110 plus items of proof that comprise the investigative file, they withdrew their appeal. So the order was final. We issued the emergency order, I believe, on May 19th. That same day, we also issued an emergency cease and desist order against Medway. And in that case, we effective immediately, they were to cease and desist from conducting air carrier flights when they did not hold an air carrier certificate. They initially were going to, they initially appealed that, and that was resolved. In addition, we entered into negotiations with them. And in those negotiations, let me back up just one moment. In November of 2004, while they were renting out a certificate, and this wasn't the first certificate that Medway had rented out, because they were an ANI's American Air Network certificate, and I think one other possibly illegal air carrier before that. However, they set in motion the application process for an air carrier certificate in the southern region, they being Medway. But while that was going on, they were still operating as if they had a certificate when they did not. So we ended up resolving that case also by entering into a settlement agreement. Under the terms of that settlement agreement, the emergency cease and desist order was construed as a basis for and a demand for civil penalties against Medway for violations of Parts 91, 119, and 135. They agreed to pay a $1 million civil penalty, which kind of makes you think they were making a hell of a lot of money operating as an air carrier when they didn't have a certificate, albeit it's under an installment plan. They agreed that FAA would consider the allegations set forth in the emergency cease and desist order as findings of violation history for purposes of any future legal enforcement actions arising from violations of FAA's statute or the Federal Aviation regulations. They were going to amend their application for an air carrier certificate by reapplying, and agreed that they will not use any business or corporate name other than Medway Air Ambulance in operating as an air carrier if and when they get a certificate, or while conducting any other aircraft operations. And they agreed that if they were to seek the use of a different business or corporate name, it had to be approved in advance by their principal operations inspector. As part of the application process, they agreed that they must demonstrate that they meet each and every requirement of Part 119 and 135 for the issuance of an air carrier certificate and op specs. including a finding of a presently satisfactory compliance disposition. And this was a determination solely to be made in the discretion of FAA. They also agreed that the functions and responsibilities of the Director of Operations, Director of Maintenance, and the Chief Pilot shall be exercised only by persons approved by FAA, and that those functions and responsibilities at no time may be exercised or delegated to Richard Moore, who was the principal of Medway. In addition, they agreed that only aircraft owned or dry leased by Medway will be listed on their op specs, and no other aircraft, including aircraft that may be wet leased by Medway or their successor or any company in which Mr. Richard Moore is an officer, director, or shareholder, will be allowed on their op specs. In other words, we're limiting any role that Mr. Moore could play in any future operation. Now, we haven't forgotten about the other, let's see, I guess the other 4 entities, M&N, Alton, I forget, whatever. We are still investigating and working those cases, and if the evidence supports it in the future, we will be taking enforcement action against them too. We dealt with M&N first, with Medway first, because they were the biggest and most egregious violator, and the group that's working this, they're working at a pretty feverish pace, and you really can't do it any faster than they have been processing these cases. So